these laws really originated as a fix for common law fraud claims that had very difficult evidentiary burdens for plaintiffs to prove. It was very difficult for plaintiffs to win under these the traditional common law fraud claims. Also, the damages in those cases tended to be quite low, obviously, and so oftentimes the cases weren't economically justified for either a plaintiff or an attorney to bring. So beginning in the 60s, we began following the guidance of the FTC, as was already discussed. A lot of states began creating their own consumer protection acts to call different names. I think there's probably 57 different acts and 57 different names of the acts. But they were really meant to be a fix for the deficiency in the common law at the time. These original acts tended to look something like the original federal act. They tended to be enforced by the Attorney General. The Attorney General could enjoin whatever sort of deceptive practice was occurring. They could also seek restitution on behalf of the harmed consumers. But over time, in certain states, Missouri being one of them, we've seen a devolution, if you will, of these laws from their original purpose and the original goals into something very different. So again, originally these laws were meant to give incentives to consumers and attorneys to bring claims that were often for very small amounts of money, and also to do something to help them with the evidentiary standards, the burdens that were quite high under the common law fraud claims. So we initially saw a movement towards private actions being available, not just actions brought on by the Attorney General, but also private actions. After that, we would see class actions becoming available. We saw attorney's fees being possible for plaintiffs in these cases. Punitive damages, which tends to be a little bit rare, Missouri has that. And so all of these things were safeguards initially kind of put in place to give consumers the incentive to bring these claims, to make it possible for them to prevail when they did have a legitimate claim. But over time, we saw more and more of these safeguards added up, and they really became quite redundant. So for example, the purpose of attorney's fees is to give a plaintiff's attorney the incentive to bring this case. Even if the damage award is only going to be a few $1,000s, at least they'll get their fees paid. And so that's the purpose of that. But on top of that, we would see punitive damages offered as well. We would see safeguards about, for example, in Missouri, you don't have to prove that the consumer was acting reasonable when they relied on whatever business practice induced them to enter the transaction. We actually don't even have to have reliance or causation. And so someone may not have even relied on a business practice at all in entering into the transaction. So in other words, there was kind of no causation between the business practice and their eventual harm. And so, individually, each of these serves the purpose of giving consumers the incentive to bring these claims, many of which are obviously very legitimate, giving attorneys the incentive to take these claims, but there's just been an additive effect where there's a lot of redundancy in the law. We see that especially in the class action area in this state. So the whole purpose of class actions, of course, is to aggregate damages. So it makes sense for consumers to bring these claims. It makes sense for plaintiffs' attorneys to file these claims because the aggregated damages end up being quite high. But on top of that, in Missouri, we also have punitive damages in class action cases. And so there's, again, just kind of a redundancy in the safeguards. So it's not surprising that this continued expansion has resulted in a dramatic increase in consumer protection litigation in this state.
I think the FTC's interest here, and I should note that I'm speaking for myself and not the commission as a whole. They don't let me do that. But I think that there's no doubt within the Federal Trade Commission that there's belief that those sorts of safeguards have made the FTC's consumer protection mission stronger, not weaker, and given us more confidence that our efforts in those regards are doing more, doing more good than causing harm. And so when you see some of the data in Professor Shepard's paper and some of the empirical research about the trend in the state laws away from the federal standard, I think it raises some really important questions. I don't think there's much of a doubt at all that what's going on in a number of state CPAs is different than the federal standard. But I do think it raises some really important questions about exactly what those differences are and what their implications are, both for state consumer protection, for reforms of state consumer protection law, and for my own personal interest, what role the FTC can or should play in nudging those reforms in the right direction.
The vast majority of businesses, in my experience, don't want to mislead their customers and don't mislead their customers. Most businesses are based on establishing trust and confidence with their customers. The only ones, in my view, that would benefit from watering down the MMPA are the businesses that do, in fact, deceive their customers. Doing so, if you water down the MMPA, you're not only harming the consumers, but you're harming those business competitors, the businesses who are trying to play by the rules, but their competitors are not. I believe, therefore, that the conservative position on the MMPA is that it should remain a strong tool of law enforcement to protect the victims of businesses who would prey on the unsophisticated and uneducated, and frankly, anyone who's ripped off by a seller.
When I started practicing law, I think everyone was familiar with the phrase buyer beware, and I think that generally probably, in many ways, was probably sort of the playing field we all operated on. I would suggest to you today that it is now seller beware. In the state of Missouri, sellers and manufacturers have to beware that if they operate in the state, they're going to be subject to MMPA claims. And Don is an excellent lawyer. We have mutual friends. I've never had a case with him, and I suspect that all the cases he files are very meritorious. I've never had any information to the contrary. But unfortunately, in the last 5 years in particular, it's gone from good to bad to ugly. And I've seen nothing but ugly for the last 5 years.